The draft Digital Personal Data Protection Rules 2025 is a long overdue advance in the direction of enforcing the fundamental right to informational privacy for Indians, affirmed by the Supreme Court of India in the landmark case Justice K.S. Puttaswamy versus Union of India. The Digital Personal Data Protection Act, which these draft rules seek to enforce, was passed in Parliament over a year ago. This 7-year wait has most likely not been without cost for the privacy of the data of Indians, as it coincided with a period that saw a rapid growth in digitization. The proposed rules offer direction on how online services will be required to communicate the purposes of their data allocation to users, safeguard children's data online, establish the Data Protection Board of India, set the standards of government agencies to follow to be exempt from the Act's provisions, and spell out the procedures to be observed if personal data is breached by the data fiduciary. This concern regarding the proposed DPBI's institutional design have not been resolved by these proposed rules, and it may not be realistic to expect such an outcome from subordinate legislation. It is regrettable that the government continues to clog the rule-making process of a critical policy such as this is secrecy. Since the Justice B.N. Sri Krishna Committee was convened to draft the first bill for data protection, the government has consistently declined to place recommendations from stakeholders in the public domain and has foreclosed such disclosure for these draft rules as bail for legislation where the stakes are high for individual users as well as for large technology firms. An open, deliberative process is essential. It can only be facilitated when industry associations and the general public can find equal footing by being equal participants with transparency into each other's viewpoints during the consultation process. In the short and medium term, it is essential for the government to proceed with these principles in mind while never departing from the key aims of any data protection law: minimizing data collection, promoting disclosures, penalizing neglect in protecting user data, and discouraging surveillance practices both by the private sector and the government. This process must also play out in a timely fashion, as Indians have been waiting for too long to finally obtain the rights that were affirmed for them in 2070. Else, people's confidence in the government's seriousness about protecting their data from government agencies as well as private enterprises would be shaken.